Another massive loss for Rudy Giuliani that also spells doom for Donald Trump in his defamation case brought by E Jean Carroll, set for trial next month. I'm Ben Meiselas. This is the MeidasTouch Network. So Freeman and Shaye won an important bid to lift the stay on the $148 million judgment against Rudy Giuliani. That means they can begin collection efforts against Rudy Giuliani immediately. They can go after his bank accounts. They can go after his property. They can go after his pension to the degree as permitted by law. They can go after other revenue streams going to him. And if Rudy Giuliani declares bankruptcy, Rudy Giuliani would then have to try to bring this before an adversarial proceeding. But this is a non-dischargeable debt because it was intentional, done with fraud and malice. His conduct directed at Freeman and Shaye, so he will not be able to discharge this $148 million verdict in bankruptcy, meaning that for the rest of Rudy Giuliani's life, and to the extent he has an estate and wants to try to pass money to the estate, Freeman and Shaye will be right there ready to collect, and they will spend the rest of their lives collecting against Giuliani. And if Giuliani tries to hide any money from any sources and family members and others who are indirectly or directly receiving money from Rudy Giuliani. And as I said, this spells doom for Donald Trump as well. I'll go over the Rudy Giuliani order, but this spells doom for Donald Trump, and I want to explain why, as the E Jean Carroll second defamation case is set to start in January, mid-January. It'll be a few-day trial where Donald Trump's going to get wiped out. But let's just take a look at this order, because this is an order right here that I think we will see something very similar in the Trump E Jean Carroll case. So one of the things Giuliani and his lawyers were asking for is to stay or pause enforcement on the $148 million judgment until they go through all of the appeals and all of these things. Now, to do that, you need what's called a supersedeas bond. You need to post a bond with the court that's usually at least equal to the amount of the verdict. I mean, Rudy Giuliani would need to post something equivalent to $148 million or take out some loan or have some collateral that's equal to the $148 million that's suitable to the court. Obviously, Giuliani has nowhere near that amount or nowhere near a fraction of the amount. And so here, Judge Beryl Howell, the federal judge presiding over the defamation case filed by Freeman and Moss against Giuliani, gave them the green light. Start collecting. Now, Giuliani will have the opportunity to try to request a stay of the collection before the D.C. Circuit Court of Appeals, the boss of the district court, but he's going to have to post a bond if he wants to do that. Let's just take a look at this order, and let's talk about how this is going to be devastating for this concept is going to be devastating for Trump. So here was the order that was issued. It basically talks about how Giuliani, the obvious fact that the jury's unanimous jury awards were conservative as to the plaintiff's requested compensation for reputational harm due to Giuliani's defamation per se, based on the expert's calculation of the cost of repairing their reputations, and the jury's punitive damages was nearly equivalent to the compensatory damages rather than multiplied by up to 4 times compensatory damages. Reduction of the award on remitter faces some challenges. Moreover, should this case be appealed, Giuliani can avoid any claim prejudice and obtain a stay of enforcement at any time pending a full supersedeas bond pursuant to Federal Rule of Procedure 62B. At any time after judgment is entered, a party may obtain a stay by providing a bond or other security. That's what I was talking about before. Given that, quote, the stay operates for the appellant's benefit and deprives the appellee of the immediate benefits of his or her judgment, a full supersedeas bond should be the requirement in normal circumstances. So there you have Judge Beryl Howell kind of just putting her finger right into the sore spot on Giuliani and saying, okay, you're going to have to post a supersedeas bond with the Court of Appeals, $148 million, buddy. Good luck doing that. And that will be able to protect you and the rights that you are claiming that you should have right here. Post that bond, $148 million. Goes on to say, Given that the stay operates for appellant's benefit, although the court has discretion to depart from the usual requirement of a supersedious bond for the full amount of the judgment, the burden is on the moving party, Giuliani, to objectively demonstrate the reason for such departure. Thus, to obtain a stay of the enforcement of that $148 million judgment pending any appeal beyond the 30 days of the automatic stay, Giuliani would have to comply with the usual requirement of a full supersedious bond or demonstrate why the requirement should not apply, a showing difficult to make when there is more than a, quote, reasonable likelihood of the judgment debtor's inability or unwillingness to satisfy the judgment in full upon the ultimate disposition of the case. Another troll by Judge Beryl Howell against Rudy Giuliani there. In conclusion, and for the reasons set forth above, it is hereby ordered that plaintiff's motion to dissolve the stay and of execution and for leave to register is hereby granted. And so, in other words, saying that, all right, go start your collection efforts right now on Giuliani and go for it. Order that the stay of the execution of final judgment entered December 18, 2023, and of proceedings to enforce it, provided under Federal Rule of Civil Procedure 62A, is dissolved, effective immediately. And then you see even there, Judge Beryl Howell is saying, look, what the jury actually awarded Shaye Moss and Ruby Freeman was fairly conservative. They could have went higher, is what Judge Beryl Howell was saying. And they chose a reasonable amount of about $16 million on economic damages each and about $20 million for emotional distress damages. And they only did $75 million for punitive damages, Rudy Giuliani. You should be grateful, Giuliani, for what the jury ruled here, Rudy Giuliani. And that's what Judge Beryl Howell was saying. Now, take this exact thing in the context of the Trump case that is scheduled for trial in January, right? So you have there a defamation case brought by E Jean Carroll. She previously prevailed in the previous defamation case that went to trial, where she received a $5 million verdict. Trump, unlike Giuliani, was able to post a supersedious bond. So E Jean Carroll's collection efforts there are stayed pending the appeal process by E Jean Carroll and by Donald Trump in that matter. But now with the new defamation case that's scheduled for next month in January, this involves Donald Trump's defamatory statements made when he was in office. And the damages expert is the same damages expert who testified in the Giuliani case, Dr. Humphreys, a professor from the Northwestern University. And Dr. Humphreys is going to post a much bigger number here for the overall reputational damages that E Jean Carroll suffered as a result of Trump's defamatory statements. Also, for punitive damages, Donald Trump continued to defame E Jean Carroll after he lost in the first case. So, as I said, I think that there's a world where the jury hits Donald Trump with a verdict for somewhere in the range of 10, 20, 30, 50, $100 million, maybe more in this E Jean Carroll case. And then Donald Trump is going to have to post a supersedious bond equal to that amount. And Donald Trump, unlike Giuliani, has the resources to do it. Otherwise, E Jean Carroll is going to collect, and Donald Trump does have that money in his bank account. And there's a financial monitor because of the New York Attorney General civil fraud case monitoring Trump's account. So Trump can't hide that money like he maybe once was able to do. If he moves any money more than $5 million, it immediately gets flagged for that financial monitor who was appointed in the New York Attorney General civil fraud case. And so immediately what E Jean Carroll could do if Trump doesn't post a supersedious bond for, I think with the huge amount the verdict is ultimately going to be in January, we'll get that before February 1st. E Jean Carroll is going to go right to that bank account, right to that financial monitor in the New York Attorney General civil fraud case, make sure that money's there and just take it. just seize the money if Donald Trump doesn't post doesn't post the supersedious bond. And so and I said this before, between the New York Attorney General civil fraud judgment, which I think will hit in January or early February, the latest, by Justice Arthur Engoron, that's going to be that case is wrapped up. There's closing arguments in early January, but we'll get an order there from Justice Engoron, I think in the next 60 days or so. Plus the E Jean Carroll verdict, which we'll get before February 1. So Donald Trump can have between $500 to $1 billion in judgments against him by February 1 or the first week of February. Think about that. And then Trump's going to have to post supersedious bonds to appeal. So you see in action what's happening to Giuliani doing the Trump routine. Now, when you have Trump, who's going to be confronted with the same things, you're going to have Trump get hit with huge verdicts and have to post supersedious bonds. And then you're going to see orders like the order here by Judge Beryl Howell in D.C. But in the case in New York, it's Federal Judge Lewis Kaplan who's presiding over the case. And Judge Kaplan, or in state court, Judge Engoron, I think they're going to look at stuff like this, that like, okay, like this is what the law is. Look at what Beryl Howell's doing over there in D.C. She's a trial judge. It's not precedent for other trial judges, especially in state court systems. But look what other trial judges are doing. Post a supersedious bond or shut up. And I think that's what they'll ultimately do. So another bad day for Giuliani. A good day, for Ruby Freeman and Shaye Moss. They can start their collection efforts, and this is a signal to what's going to be happening with Donald Trump in the E Jean Carroll defamation case when a verdict is reached against Trump there. E Jean Carroll's using the same expert as was used in the Freeman and Moss case. I expect a massive verdict there. We'll keep you posted. Hit subscribe. We're on our way to 2 million subscribers thanks to your support. Check us out at patreon.com/MeidasTouch. Have a good one.
Hey, Meidas Mighty. Love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.